Well, I'm Michael Humphries, QC, and I've got with me today on this JPLC 2019 podcast David Elvin, QC of Landmark Chambers, who's just given a paper on environmental law and planning, the road ahead. And David will be known to many of you as one of the leading lawyers in administrative planning and environmental law. And David's paper has examined three broad themes. He's looked at developments in EU environmental law over recent years. He looks at the effect of the European Union Withdrawal Act 2018 on environmental law in the UK post the withdrawal. And then he looks forward to how UK environmental law may develop in the future. David, first, welcome.
Thank you, Michael.
David, on the first of those themes, your written paper explores some of the recent trends in EU environmental law, and particularly the Commission's increasing sort of intervention in environmental matters and enforcement. And can you just, perhaps for listeners, talk a little bit about that?
Yes. Well, as people will be aware, the Commission's got a policing role, particularly in the area of infraction, where it can take a view on the basis of complaints received or its own investigations that a member state has not been applying EU environmental law correctly or has been misapplying it in some way, and it may take proceedings, first informally, and then if a resolution isn't achieved formally, following a reasoned opinion, may then take matters before the European Court. And importantly, in the European Court, it has been pursuing a number of issues which, to be fair, have been backed up also by private litigation. I mean, you have cases such as the Commission against Poland in 2017, the Białowieża forest case, but it's backed up by other cases in the same area of habitats, such as those brought by Peter Sweetman, the Grayson Sweetman case, People Over Wind, the Dutch nitrogen cases and the like. And they've been taking a very much more rigorous approach to assessment of environmental effects in the area of appropriate assessment than national courts have been taking.
And that's interesting. I mean, do we know why that is? You know, the paper, I think, makes it clear that there is this greater trend towards intervention, greater sense of enforcement and conformity. Is there a reason behind that, or is that just the evolution of the environmental system?
I think it's a development of policy. I mean, you can see it going back some years. The introduction of the precautionary principle 18 years ago, which I think the Commission refers in its recent report to being operationalised about 2000, weaponised, I think I said in the lecture. But you can see it in the Wadensee case coming to the fore. And the court has taken a very rigorous approach, much more increasingly, for example, see Eleanor Sharpston, the Advocate General's opinion in the first Sweetman case concerning limestone pavements. And you can see them taking the view that really, as a matter of policy, we don't want to use the two-stage test for screening and appropriate assessment as anything other than, at least at the screening stage, an absolute minimal threshold. And you can see that in her opinion, the why should we bother test.
Yes.
And the court has now, and other Advocates General, particularly Advocate General Cocotte, has picked this up. And we now have a position where, as a matter of policy, not just as a matter of law, the court will simply not allow you to screen something out if there is any risk. And they're not interested in whether, as a matter of fact, you could, by best scientific evidence, screen it out having regard to mitigation. It's not just the pragmatic question on the facts, as Sullivan J. explored in the Hart case and the Court of Appeal in the Smith case. It's actually a policy-driven issue as well as a factual one. So there's no getting round it.
No, and that's absolutely fascinating. Now, you know, I mean, the next theme in the paper is about the Withdrawal Act. And, you know, you explained during the paper that broadly the legislation takes European environmental law as it existed on with the withdrawal day and transposes that or takes that into domestic law, but clearly there are some aspects of European law for which that can't happen. Even on day one, there are certain things we can't do. We can't transpose the European Commission into domestic law. And so, I mean, what are the principal things of that type, and kind of how is the legislation handling that?
Well, there are two issues. One is the substantive law, and effectively, cutting a very long story very short, the Withdrawal Act effectively converts pre-exit day law into UK law. There are a whole raft of legislative amendments in SIs, over 600 at the moment. For example, the SIs amending the Habitats Regulation, and all the EU-based matters,
yes,
such as the references to the Commission, to Natura
yes,
2000, are all turned then into national concepts. So instead of the Commission being the adjudicator or the body to which you report, it's the Secretary of State or the Welsh Assembly or whichever is the appropriate national authority. So you have a whole series of conversions so that it will operate within the national system. The second line is the procedural line. Well, what's going to replace the Commission and its policing role? And the government's answer to this, and it was published in a draft bill put out for consultation purposes last year, is the Office for Environmental Protection, the OEP. And it will follow a broad approach similar to the Commission in that it will have an informal investigatory role. It can then try and resolve matters by agreement, and if it can't do that, it issues a reasoned decision. And although the reasoned decision isn't binding, if it doesn't get a satisfactory response, it can seek, at the moment, under the bill provisions, Clause 25, judicial review from the High Court.
Yes, and there in the paper and the presentation you gave, you've identified one or two ways at the moment which you thought that they hadn't perhaps thought this through as much as they need to, and clearly, I'm sure these things will evolve over time. But I mean, just touch on one or two of the areas where you thought that maybe a little bit more thought needs to be.
Well, they were matters identified by the consultees, and I say primarily Professor Richard McCrory and others who taken part in a very lengthy consultation process. The first one is that the approach of the Commission is quite intensive, and the European Court, the Commission against Poland case, shows a rather more intensive scrutiny of the facts than judicial review tends to give. And so the UK approach, based on judicial review, might be a watering down of the Commission's approach. The judicial review process would exclude the ability to fine, at least in the current basis. So the ultimate the ultimate sanction in the case of infraction, if the member state doesn't comply, it will be fined by the court. It's not currently proposed to do so here. No. And the judicial review model in Clause 25 has been said to be a fairly clumsy way of giving rise to this. And it contains, for example, a carve-out for delay, which gives rise to a considerable number of problems because it would allow the OEP to reopen decisions which had long passed their normal judicial review period.
So that kind of brings us into the third overall theme, and we've got a couple of minutes just to maybe touch on some things there, which is how you see UK environmental law developing over the next few years. And I suppose what people may be interested in is, what are some of the opportunities for us?
Well, the biggest driver potentially is climate change, of course. And with the modification of the target reduction in emissions to 100% by 2050 in the legislation, the amendment to the legislation introduced earlier this summer, and with the Climate Change Committee's report on zero emissions, that has the biggest potential for altering approaches to policy at all levels, particularly planning, not only low carbon homes and changes to vehicle emissions, electric vehicles, but to agricultural practices, to food consumption. As the retiring DEFRA chief scientist made clear just before the summer, it will require a massive commitment from government. And the current proposal, which is to publish environmental improvement plans under the Environment Bill I mentioned earlier, they have to publish a plan for 15 years. Well, the Climate Change Committee was saying the proposals for changes in policy and the like would have to be clear by 2025. So if the government remains committed to the zero emissions target, and we all know how serious the climate change issue is, then it will have to be in the first of the environmental improvement plans. There seems to be little option but to include it within it.
Well, David, thank you for the paper, for your presentation to the conference, and for this podcast. And as ever, it's been a pleasure talking to you.
Well, many thanks.